Welcome, everyone, to this Legal Office Hours webinar. Today's topic, how to handle employee issues when buying a business. My name is Will Smith. I'm the host of the podcast Acquiring Minds and a partner in Minds Capital, a fund that invests in independent sponsors. Attorneys James David Williams and Bill Barlow are going to host today's session. You know James David and Bill, they're partners in Barlow and Williams, and their practice specializes in small business M&A. They're at the front lines of the market. Their focus is helping searchers and sponsors just like you do your deals. They also represent sellers, so they understand well both sides of the table, both sides of the transactions in our market. The way we run these, as always, Bill and James David will give their presentation, and then we'll move to Q&A. To ask a question, use the Q&A function of Zoom. We don't use the chat. If you have a very detailed question, very in the weeds, sometimes we get those. It can be difficult to send those out here live, to answer those live. But if you are not logged in anonymously, log in with your real name. James, David, and Bill can get back to you after the fact with an answer to that question. So ask it anyway, just be sure you're not anonymous. We are recording the session as always, and so you'll receive a link to that recording by email, as well as the slides that you're about to see in the next day or two. And finally, some links in the chat to connect with James, David, and Bill, Barlow and Williams' website, and then each of their LinkedIns, connect with them there, and their email addresses. Bill, James, David, over to you guys.
All right. Well, thanks everybody for joining. As Will said, this is about employee issues when buying a business. And just a little bit about us. We operate, this is everything we do every day is helping people buy and sell businesses. Our model, we're a flat fee model with milestone-based pricing. So that's just a little bit about us. And today we're talking about something that is extremely significant when you buy a business, and that's how you deal with the employees. And this is both before closing and after closing. And I'll preface this with saying this is actually one of the most sensitive issues when you're dealing with sellers. A lot of times there's going to be a lot of discussion about when to talk to the employees and what that relationship looks like. So this is a good one to pay attention to.
Okay, so we'll kind of start with the video jump there. We'll start with the more kind of basic diligence items that you'll be asking about the employees in the target business. So you're going to want to see an org chart, right? And that will, depending on the level of sophistication of the business, depending on how many employees, right? It may only have 2 layers or there may be 4. It sort of depends. And then you sometimes you'll see one person in more than one spot in the org chart. That can be a little bit of a yellow flag if the owner or the owner's wife or husband is doing 4 different job functions, but that's one of the reasons you ask. But you ask for the org chart to kind of get a sense of who does what, right? Who reports to whom. And it's a first cut approximation of who can be the key employees in a business. Although sometimes you actually get in the business and find out that the person, maybe the IT support person, is actually the one who knows how all the systems work, and it's maybe not the salesperson that you thought was the key person. We've seen stuff like that happen, but anyway. But you look for the key employees, right? Those kind of 1 or 2, maybe 3 individuals who are, essential to the business. Often it's a kind of head of operations type role or a head of sales, but it doesn't have to be. But those are kind of the key ones usually. But you also, kind of get a summary of how many employees there are, roles, right? Compensation, right? If you due diligence, and it turns out that everybody is underpaid by 10, 15%, right? Then you need to build that into your model that you're going to have to give these people raises, or you're going to lose your people. And sometimes if you do that, then those EBITDA margins drop and the deal doesn't look great anymore. So one of the things to watch out for in diligence. Then you also want to look at things like accrued vacation, commissions, and bonuses. This last bullet, it's actually a working capital issue. Because it does vary a little bit based on what state you're in. But in a lot of states, if employees have accrued vacation, that is a liability on the balance sheet, right? That's compensation that they have earned, and so it's a liability on the balance sheet. And you just need to be aware that if there is a bunch of vacation, right, there's a couple different ways that could be handled in a transaction. It could be that employees kind of get paid out at closing, and then their vacation kind of resets. As you might imagine, that can anger employees at times. If they had a big vacation planned, then 3 weeks before all their vacation gets paid off and wiped out, they're not going to be happy. So often, accrued vacation is just assumed as it's an assumed liability, and the purchase price gets reduced. Commissions, bonuses get handled differently depending on what time of year it is. Often there's just sort of a proration, an agreed proration between buyer and seller.
So a couple more employee diligence items, W-2 versus 1099. So a 1099 is an independent contractor. There are times, multiple times, where we see employers who misclassify employees as 1099. And some of the reasons they do that is because when you pay a 1099, then let's say you pay them $100, you don't have to worry about payroll, you don't have to worry about, taking out amount for Social Security and those sort of things. And the employee is like, great, I'm just getting more money. But if they are working for them full time, if they do meet the classification as a W-2, you can't do that. And so there's a couple things to consider. Number one is, what is your risk going forward if they've had misclassification issues in the past? Because even if you're doing an asset purchase, that risk can actually carry forward. So that's one thing to keep in mind. And then two is, if you were to change your practice to be what the practice really should be, then what does that look like in terms of your model, right? If all of a sudden the employees are upset with you and so you have to pay them more, does it work? And if you're dealing with a business that has lots of 1099s, they've got lots of people like that, sometimes that can make a very significant difference. So that's one of the items. Another item is immigration status and I-9s. I mean, especially now in today's day and age, there's a lot of focus on this issue. And so employees you're supposed to get I-9s from the employees, and that basically fills out information so that you check to make sure that they actually are able to work in the country. And most most employers don't technically do this the way they're supposed to. And so, there's kind of levels of like, okay, you filled out the form pretty good. You didn't get the photocopy of the driver's license, but that's okay. Um, you know, but you want to make sure that they're doing their diligence and that there's no issue there. Existing equity incentives. So there is oftentimes either equity, so employees have equity in the company, which actually can be a little bit of a problem because if they're being bought out, then if you're using an SBA loan and you buy them out, then they no longer can be an employee of the company. They have to be an independent contractor. Um, but even beyond that, a lot of times it's common to have something called phantom equity, where basically the seller just says, okay, I like you as an employee. I want to do right by you. If I sell the company, I'm going to give you, 1% of that sale or 2% of that sale. And that's something to know about. That doesn't create the problems from the SBA loan perspective. But, if they're going to get a chunk of cash in their, bank account, does that change anything for them? Will they be expecting something similar from you going forward? Those are important questions. And then existing benefit program retirement plan. So in general, in I think 95% of cases, people are keeping the same benefits programs. Usually it's a 401k, medical, dental, that type of stuff. Occasionally you're going to see defined benefit. we've really seen it mostly in the context where they're union employees and that union has a separate sort of defined benefit plan. But we have seen a situation where there has been like an ERISA plan at a really small company, and you actually have to diligence that really carefully because there are massive costs if that gets wrong. And so if you see anything beyond kind of the normal like 401k, healthcare, dental, then you need to ask more questions. I'll just say one more thing about this because it actually came up recently on a deal. If you are doing a transaction using a Rob's 401k, you're using your retirement account to fund the transaction. As part of that process, the existing 401k plan that the target company has will have to be terminated, and they basically have to be terminated and have the new plan. That can create some issues. For instance, we had one deal that recently happened where there were some employees that had loaned themselves money out of their 401k. And then when they terminated that plan, that loan counted as a taxable distribution to them, which meant that they got paid basically penalties for that early withdrawal. And the buyer had to basically go out of pocket. Luckily, it wasn't too much, but the buyer had to go out of pocket to reimburse them for that extra expense because there was no other way to get the deal done. So again, an issue that doesn't happen on all deals, but just know if you're doing a ROBS, there are special issues. If you're using a retirement account to fund the equity check, there's some special issues involved.
Yeah, fortunately, that was Bill's deal and not mine. Um, Although I did have one recently where the target was violating state law pretty clearly on pay periods. They weren't paying employees frequently enough, and so we had to assess the potential exposure of that because employee liabilities, right, as Bill said, and I'll double down on this, right, those carry over even in an asset purchase almost all of the time. And there are some states do this by statute, like California, but other states do it by just sort of common law principles. But the justification should be pretty obvious, right? States want to protect employees, and if employers could circumvent employment laws by, changing the employer, then, right, a bad actor would just have a new company every 3 months to get around things. So, to prevent things like that, you as the buyer will be assuming any sort of employee risk for the most part. There's a few things that wouldn't, right? Certain lawsuits, things like that. But uh, anyway, next item we'll kind of shift to this says post-acquisition employee compensation, but you really need to think about these before closing. If you don't think about these until after closing, then you're going to be caught on the back foot, and um, you're going to be looking. Your employees are going to think you're weak. So one is kind of equity incentives. So this can be true equity, which if you're going to do true equity, this can look a few different ways. There could be actual equity, there could be profits interest. But if either of those you want to build into the organizational documents of your entity pre-closing, because it's just much more complicated to do it later, especially if you have investors in play in your acquisition. But you can, if you have that scenario, you can create something kind of like an option pool, right? It's not really options, but a pool of equity that you can give to employees. And it's better to do that up front to agree on numbers of how much that could be. There could also be phantom equity, the way, something Bill talked about, which phantom equity is a purely contractual right. The tax treatment is different, and certain vesting can be different, things like that. But um, You can assume that in the couple of months after you take the owner's seat, that just about every one of your employees is going to knock on the door and say, "Hey, boss, I think I deserve a raise." So you may have, in your diligence, decided that you're going to do across the board raises for everybody. That happens sometimes. Other times, people come in and say, I'm freezing compensation for 6 months, and then we'll assess. And we can kind of get into, there can be retention bonuses to help smooth that process too, right? You could say, hey, I'm freezing it for 6 months, but everybody who sticks around is going to get a bonus at that point, right? You can have all sorts of permutations of this, but whatever your plan is, you need to have one around the request for raises because it's going to happen. There is not necessarily a right answer. There's not necessarily a wrong answer. Just know that whatever you do, the employees will talk. So don't assume that you can be particularly selective about raises. You probably could, you can vary raises based on different levels of the org chart and different roles. But if people get different raises and they're in the same role, you can expect some blowback. Um, from the well, maybe everybody. Um, and then performance bonuses, right? This could have been built into pre-existing contracts, right? If especially around salespeople. But sometimes ops people have performance bonus targets too. If those existed pre-closing, you probably just want to keep them as is post-closing for a little while until you get a better sense of what the KPIs, what the key performance indicators should be for the different roles. But performance bonuses can be very powerful, right? But if you're going to use them, pay for what you want because that's what you're going to get.
Um, and another couple things that I think are good to talk about, especially in the pre-closing period. We often get asked about when do you start having these conversations? And this is always a tricky point with sellers. In an ideal scenario, the seller, as soon as you're signing the LOI, sometimes we've even seen it happen before. They take you down, they have you meet all the employees, and you talk to them and do all of that stuff. That's not always the case. There are other sellers that say, I don't want you to talk to anybody until after you've closed. And that's pretty dangerous for you because, you just don't know what that relationship is going to be like. So you need to push back if the seller says, don't talk to them all before close. I get it. The seller probably doesn't want everybody to know that they're selling the company. They don't want the disruption on that, but you will have to have, some type of talk about that with them. Also know that this is a very natural transition point. After the seller has left, a lot of times the employees are like, well, I was kind of hanging on because I, had this relationship with the seller and the seller's gone. And so I'm, maybe I'm gone too. And so that's another risk to assess. And the other point that I would also say is that you should try and get a sense of the replaceability of your employees. And I say that because there are certain companies, especially in the trades, especially if they're specialized, where you might have employees that are older and are looking to retire themselves, and there might not be as much ability to replace that skill set in the area where the target company is. And so we have talked to business owners where surprisingly, at least to me, the main issue was not getting in work. The main issue was having employees that were qualified to do the work. And so, a lot of times when we talk about these deals, we're focused on revenue. We're focused on making sure that money is coming in, but you do have to service that. And there are many companies where that's actually a difficult problem if there's some skill set. So don't make sure you don't neglect that when you're doing your business diligence. All right. So the next thing we're going to talk about is non-compete agreements. So this one is particularly tricky. So non-compete says, let's say that you bought I'll just be generic, right? You bought an HVAC company and you have some guy that's like a really great sales guy that's going out getting all your leads, and you're like, you know what? I don't want you, I want to compensate you, but I know that if you left and started your own HVAC company, you could probably, do really well, might even take a lot of the existing customers with you, which the existing customers is actually a separate point about non-solicit. But you might be worried about the ability of employees to compete with you. And so what you would do is you can offer to have a non-compete. And basically you say, I want you not to do the open or work for another business that does the same type of business that I do within a certain geographic area. Now, unlike with non-competes with the seller, which are enforceable basically everywhere, and you can get like 5 years, non-competes with employees is much more varied. First of all, state by state, some states you can't even do it, famously California, you can't even have a non-compete. Um, and even where they allow it, they are gonna look at how long, is it reasonable? Like what's the scope of it geographically? And so you have to be a lot more careful, because just because you put it on paper doesn't mean it's actually enforceable. And that's something to keep in mind. The other thing to keep in mind with non-competes is there will often be a very negative reaction. Not often, but there can be a negative reaction for the employees. They see this non-compete and they're like, whoa, what are you trying to do? You're trying to like take away my livelihood. I can't work anymore if I leave you. And so we're going to talk about non-solicits next time, but if you can sometimes talk with the seller. And sometimes we've had situations where a buyer has talked to the seller and the seller says, look, I looked at this agreement. It has this non-compete. I know my guys, they're not going to like this. My employees are not going to like this. And so you should do something else that also gives you protection, but they're really going to not like this. And I would say, listen to your seller when they're telling you that, because you really need to start this relationship off on the right foot. And for better or for worse, whether it's justified or not, if they perceive you as this like really aggressive person coming in and trying to be really aggressive with them, that's not going to be the best way to start the relationship, even if you're offering market terms. So, it's just something to keep in mind.
Yeah, and we'll talk about states more, right? California is one extreme. Florida's probably on the other. They just passed legislation to make non-competes more permissive. But some states, I think Washington, I think Minnesota has this too, where people have to be at a certain salary level for a non-compete to be valid. I think I had one and looked something up in Maine where the employee has to be employed for a period of time, either 6 or 12 months, maybe longer. I don't remember, before the non-compete would even kick in. So it can be signed, but it wouldn't take effect until later. There's other states that every state is wildly different, and things change with non-competes. Sort of every year, there's a few states that pass a law that changes the rules. So you just have to be aware of that. I would also just note, right, on the three elements, the scope of restricted business might even need to be tighter than that. It could be like the scope of their role, right? Not just, right, you can't necessarily prohibit someone even, and again, this is state by state, but right, if somebody is a salesperson, right, then you might not be able to prohibit them from taking an operations role within the same industry, depending on what state it is. So, like even the elements vary by state.
Guys, real quick before we move off the slide, just a question from the audience confirming you did say it, but this is about employee non-competes, just to
Yeah.
underline that, not sellers. But give us a few sentences on seller non-competes. Those generally are quite enforceable.
So seller non-competes will be enforced in every state in the union, including California. There are in California, there's special statutes that allow it. But yeah, sometimes brokers or sellers will say, oh, there can't be a non-compete, blah, blah, blah. There definitely can be. Um,
And there should
And
be.
there should be, right? If there's pushback on the existence of a non-compete in your kind of main purchase agreement, then that's a problem.
Yeah.
Um, so
And frankly, it's a very weird thing. The one place where sometimes sellers push back and it's sometimes okay is they might have a different business that they're doing and they want to make sure that that's carved out of the non-compete. And like so they might care a little bit about the scope. But if they're fighting you on like how long or geographic scope, you got to be asking yourself, well, like, what's your plan, man? Like, I thought you were most of the time, it's like you're getting out of this business because you don't want to be in this business anymore. If you care a lot about it only being 3 years and not five, that's not really, that's indicating that they might not be, telling you the whole truth about what their future plans are. So.
Thank you.
on to non-solicit. So non-solicit agreements um, cover, right, customers, employees, and suppliers, right? So you're the existing customers and sometimes potential customers too, but existing customers, employees, and your suppliers. So these will be enforced. There do have to be time limits, and those can vary by state again. But even California will enforce a non-solicit. Um, there have been quite a few lawsuits about those. Some of them pretty high profile. But what it basically means is you can leave, you employee, you can leave, you can start up a competing business potentially. Right? We'll take the California example, right? You can start up a competing business across the street, but you can't take the customer data, right? You can't take the customer email list and send out a blast, right? Can't do it. You can't try to poach my employees, right? You can't, try to have lunch with your coworkers. Say, hey, come work with me. You can't do that, right? And the same thing, they can't try to take your suppliers. Um, Same way, it's a more, it, it's easier to understand conceptually a non-solicit versus a non-compete, right? And that's why they're enforced much more because these are right, kind of right. Your customer list is a core business asset, right? Your employees core business asset. Well, if you're just trying to poach those customers, you're stealing, right? That's a much easier kind of construct for people, lawmakers, judges, and employees to understand. There tends to be much less pushback on non-solicits also.
Yeah, and I would say a lot of times, a lot of the things people are afraid of with non-competes, non-solicits actually takes care of a lot of it, right? Like, even the, whatever random example, a lot of times what you're really worried about is them taking your customers, right? And that's really protected with non-solicit agreements. And so I would say, if you get pushback on employees and non-competes, then you should really say, okay, well, am I really getting what I need from the non-solicit anyway? And are they okay with the non-solicit? And a lot of times in our experience, when you kind of look into it, we've had a number of buyers that had some pushback from employees on the non-compete, but they were happy to sign up to, long restrictive non-solicits. And they said, you know what, I think I can live with that. I'm not too worried about them being in the same industry as long as they're not touching my customers, or my employees or my suppliers, that type of stuff.
Yeah. And that dynamic, right, doesn't exist in every industry, right? There are some industries where you still want that non-compete,
Yeah.
but in broad strokes, the non-solicits are more palatable.
Yeah. And just so you know, like a thing to think about, like why would you need a non-compete if you already have a non-solicit? Well, let's say you have a business that's just continually, doing projects for residents, like constructing something in their landscaping or whatever, right? Um, and there's only so many of those in that geographic area, right? That services that much. And so if they started their own and even without directly soliciting your customers, because your customers are always churning, you're always getting new customers in anyway. And if they were to start a competing one, that would really take away because, there's only so many that you can have in a certain area. So anyway, those are just some thoughts about why you still want non-competes, even if you have non-solicits. So
Okay, so that wraps it up. Short slide deck this month. Um, Hopefully the questions will fill things in. I think people have already started to ask some. Uh, but before I give it back to Will, we're Barlow and Williams. All we do is mergers and acquisitions in the lower market, lower middle market, whatever those terms are supposed to mean. We do deals. This is all we do is M&A. We represent buyers and sellers. We use flat fees and milestone-based payments. There is going to be some variance in milestones structures based on deal specifics, but we're happy to talk about that kind of in a more granular detail, but not necessarily on webinar, right? If you have questions about that, feel free to reach out. We'll get back to you, but those tend to be more specific, so probably not going to talk about that stuff on the webinar. Anyway, I've bought everybody some time, so let's hand it back to Will.
Thanks, James, David, and thank you both for, as always, a fantastic webinar. This one we did last year, and so I remember it, but I relearn and learn new stuff every time. And I think it was last month where we touched in different webinar, different topic, but we touched on non-competes. It got questions. This is always a big question for buyers, so an important topic. Bunch of questions, yes. First one from me. So in the case of, let's say a non-solicit violation, is this a case, as with so many in our world, that it probably won't make sense to litigate anyway? So this is all about, being preventive, threatening people, scaring people off from doing this, but it's not something you're likely to pursue. What do you think?
Possibly this is one where you would actually, because a lot of times final judicial resolution would be at the preliminary stage. What you would do if someone was violating it, you would file a complaint asking for a preliminary injunction, temporary restraining order, right? And if that is granted, and there would be some cost with that, a little bit of back and forth, probably one hearing, maybe not more than that, right? So maybe just one round of briefing, one hearing. If you get that TRO, you kind of won, right? That's an order telling the person to stop. And then if they violate it, well, okay, then you go after them. But from an economic perspective, you can probably get to the outcome you want if you're going to win quicker in the non-compete, non-solicit situation than in others, right? I mean, if you wanted to get monetary damages, right, then you got to follow through with the rest of the process. So that becomes more of an economic decision. But to actually just get the preliminary injunction or the temporary restraining order may not be as expensive and could be.
Great. I'm glad I asked. I was so expecting.
It is.
Sorry, James, David, say that again.
No, I mean that said, deterrence is the biggest, right, goal here.
Great. Okay. Just a quick one back on seller non-competes. Well, maybe. Well, yeah, I guess it does. Maybe this. I'm gonna take the liberty of adjusting this question. What if the business you're buying does business all over the country? How does that affect the geographic constraints of non-solicits in the case of employees, non-competes in the case of sellers?
Yeah, if the business does business all over the country, then it can be nationwide. Um, there are e-commerce businesses where it's worldwide. Right.
Again, it has to be reasonable. So if you went in front of a judge, it'd be like, well, why is it nationwide? And if the answer is because they do business nationwide, then that's a pretty reasonable, explanation.
Yeah. So it could be framed as state specific, right? That's a common way. It could be X number of miles within we're within X number of miles of our corporate headquarters. That's another formulation. But sometimes it is nationwide. And, if you've got sales in 35 states, well, then that's what it should be.
Yeah. Yeah. Great. How would you calculate a retention bonus? For example, like if the person stays 6 months, they receive 2 weeks extra of pay. Give us some example frameworks and models.
Yeah, often it's kind of 12 months is usually a more common threshold than 6. I just use 6 during the webinar, but 12 is probably more common. Um, as for amounts, that doesn't strike me as crazy. Sometimes it can be a little bit more because it needs to be kind of something in addition to a regular, right? If there's kind of an end of year bonus, right, it would need to be, at least that amount, if not a little bit more. Go ahead, Bill.
Yeah, because I mean, keep in mind the point of this is to incentivize them. So if you give them, 2 weeks worth of pay, is that going to incentivize them enough to stick around? And I would say, if you're really worried about this person staying, I personally would probably offer a little more but again, it's always about like, what your true incentives are and how worried you are about this person leaving, versus not. So.
Okay. Um, Back to equity and the equity incentive. So here we're on the right slide. It was the early topic on this slide. So if an employee has a tiny piece of equity, you'd have to buy them out and they have to exit just like the seller.
Yeah, and this can be a little bit of an issue, and I think, sometimes and sometimes people say like, can the seller just like buy out the guy right before? Well, they have a look back period is the unfortunate part about it. And so uh, it the SBA rules are the SBA rules as far as that's concerned, which means you have to wait. I don't know if it's 6 months or a year, but you'd have to wait if you really wanted them to be an employee. This is also something for you to keep in mind, by the way, as you're structuring your own compensation for employees, because on the one hand, you want to make sure they're incentivized and they're aligned with you. On the other hand, if you're looking to exit, in 10 years and you have employees that are going to be around for a lot longer than that, and you think that you're probably, I mean, if you're exiting to like a private equity company, it doesn't matter. But if you were to ever exit to another searcher, then you would have to then your employees would face the same situation as you do. And so those are just good things to keep in mind. I'm not saying you should never give employees equity, but I am saying you just have to keep these things in mind as you're kind of preparing what the future looks like.
Yeah, I'm not going to project 10 years out. My own career would discourage me from doing that. But um, and the SBA rules could change on this too. So I wouldn't necessarily try to future proof it. But if
Yeah.
somebody does have a small portion of equity, um, yes, under the current rules, if you're using SBA financing, you have an issue. Yes.
Can you talk more about the potential risk from buying a company that has misclassified employees as independent contractors in an asset purchase? What exact risk could transfer to you, the buyer, particularly if those employees are treated as employees by the buyer from day one?
Yeah. So the potential exposure could be massive. Uh, Depends on the state, but you're probably looking at something like a 2 or 3 year look back period of potential penalties of unpaid payroll taxes, and potentially overtime issues if people, should have qualified for overtime. Um, there can be other things too, but there's penalties and interest plus the actual amounts of these unpaid things. And it can be huge. And even in an asset deal, right? If you're going to hire, in a lot of states, substantially all is the wording that a lot of states use. But basically, if you're keeping the employees, you're inheriting this liability. Uh, you can mitigate your risk, right, by properly classifying people and paying people properly going forward, right? And there's sometimes you can have special indemnities, right, with sellers for these risks. And it may be that, like, if a state body did come after you, right, post closing, you can point to the fact that you've done it right subsequently and kind of beg for mercy. Uh, but if they have been doing it for a while, and you're talking about a lot of employees, the exposure can run up quickly because things like missed overtime, right, or mispaid amounts, right, penalties, interest, some of it double damages, plus attorney's fees. Like the amounts can get massive.
One other thing I'll just mention with that, sometimes we've had clients that have said, hey, I don't necessarily want to give away that we've been misclassifying people. So my thought is I'll keep the business running the way it was. And then 6 months later, I'll start, classifying them as employees. And we always tell them that's a horrible idea. Because, as James David said, your argument, um, your plea for mercy really is going to sound a lot better if you were always compliant from day one. And if you are not compliant from day one and you switch over, then you're really increasing your exposure a lot. So
There's also a realpolitik of if you do it at close and make the change, it's less likely that the employees will notice
yeah,
and pursue legal action.
yeah,
Because you
really.
can just say, like, this is how we're doing things going forward, and you know you don't have to explain. You just do it.
And is the way that this catches up with you that an employee raises their hand
Yeah,
or something that's the triggering event?
yes, it's an employee who gets terminated, goes to it, right, goes to a plaintiff's lawyer, says, what case do I have? And then they go digging, and then they file with the state EEOC, and then you've got a problem.
And in terms of mitigating this risk, structuring around this risk in the deal, can you do things like a holdback, a substantial holdback, forgivability in the seller note, all stuff where you hold on to the cash until you know that the problem has been addressed on the other side of your transaction, and then you release whatever's left to the seller. I recall I think it was last time we talked about this. The seller's going to be loath to admit they've been doing it wrong, but maybe if you structure something in there, you can kind of wink at each other that there's a problem here. You don't have to acknowledge it explicitly. So, but let me have a big holdback in here, just in case, sort of thing.
Yes, I mean all right, all options are on the table. Holdbacks are not common in SBA deals as a rule, and definitely not to the size and duration that we'd be talking about for this particular issue, because this could go a couple of years. Um, so given that, right, there are some limitations, and then the SBA toolkit, right, the kind of default is to make a forgivable seller note, which is kind of a half solution. That doesn't help you if you get a tax bill for a couple $100,000, right? Okay, well, I'll take it off the seller note. Great, but I still have to have the cash to pay that. So the forgivable seller note is an imperfect solution, but SBA rules are what they are. So you have to fit inside the box.
It's an imperfect, but also the most common solution. So,
And can your diligence provider or other accountant tally what I mean, you probably want to know what the worst case
Yeah,
scenario sum is here. Can you do that in advance of the deal?
probably, at least to an extent. If certain things you would be able to, right? The payroll taxes you would be able to calculate. Um, the, you know, could you calculate the overtime issue? Depends on how good their records were. Um, and if there's some other issue, right, it would depend on what the issue is. But you should be able to get an approximation.
Yeah. And that would be well advised.
Yes.
Yeah. Yeah. Great. I'm based in California, which always comes up in this conversation. I'm based in California and acquiring a company through a stock sale. Is the best action for me to make a new employee agreement once I start that has non-solicit parameters? So in other words, Brandon is inheriting the employee agreements that are in place, so he doesn't have to write new ones, but he wants to have non-solicit newly added. How to deal with it?
Yeah. So that is the time to do it. Um, in other states, if you're adding a non-compete, this can be a thing too. I'll add for non-competes, so not directly answering the question, but if you are doing a stock purchase and adding non-competes in a lot of states, continued employment is not always sufficient consideration. So sometimes you need to be paying people a signing bonus if you're adding covenants. Um, it's a state-specific issue, but right, if you are, adding covenants to existing contracts, some states continued employment is enough. Other states you need to pay them $500, $1,000 when they sign. In the California situation, right, we can't add a non-compete. I mean, you could, but it's not enforceable, so don't. But the time to do it is at close, right? Say, the king is dead, long live the king, right? Here's your new contract. Need you to sign it. We'd have to verify in California whether there would be kind of that need to pay a signing bonus requirement. I don't know offhand. There's also some states, just had one in Illinois, where people had to have 2 weeks notice before signing an employment agreement. You had to give them 2 weeks to consider it. There's other states where even after they sign, there's a period where they can withdraw the signature of certain covenants. So these do vary by state. But yes, what you would do is implement a non-solicit at the time of closing in a new agreement and just make sure that it follows all of the required procedures for your state.
Thank you. Are you guys aware of examples where worker classification rules at the state level versus the federal level were in conflict, and how that was reconciled? What happened?
well, I will say this, when we get to a point where you are dealing with that type of granularity, we usually bring on a specialist who specializes in classification because it can get very specific state by state and what is and doesn't count. I mean, of course, at the end of the day, like you have to, I think for states, it also can deal with like overtime and that
Yeah, no,
type of laws.
it's principally a state issue,
Yeah.
actually, and it varies. All right, some states, Massachusetts, California, use something called the ABC test, which is the most aggressive version of this line. But other states are much more conservative with the line as far as what it means to be an employee. Uh, but it's mostly a state law issue.
Yeah.
Yeah.
And when you get to the point where, if you have concerns about that, etc., like at a certain point you bring in specialists that know about this and we kind of do deep research on that particular state and what works and doesn't.
Okay. When doing an asset purchase, can the new entity assume or maintain health insurance and retirement accounts in a way that does not disrupt deductibles, loans, etc.? Or does the new company have to have all new accounts and policies? If so, what are your thoughts on mid-year purchase timings related to this?
What you generally do is you talk to the administrator about, usually they have somebody who's basically helping administer the plan and reach out and, you tell them, hey, we're going to do a change of control transactions. These are the things that we are trying to do. We generally have not found it to be disruptive, that they, even in asset purchase context, they're able to pretty smoothly migrate things over from one to another. With the exception being for the Rob's plan again, which actually wasn't even uh, that actually was a stock purchase anyway. So, but anyway, with some limited exceptions, we find it's a pretty smooth transition, and so I wouldn't worry too much about buying mid-year or stuff like that.
Yeah, it is something you need to get out in front of,
Yeah,
because, all right, benefits, payroll, all of these things for employees must be in place day one. You cannot have a gap in any of this stuff. So get out in front of it. It's doable. These big providers, right? They've done this before, but don't leave it to the very last minute.
yeah.
Hina asks, so in service businesses, if you can get the opportunity to speak with a limited, employees, will probably be a small handful, if at all, management maybe. Any tips or tricks on how you diligence their willingness to stay, or what they'll be receptive to, and being how they might be incentivized to stay? So you get the meetings with the key people.
Yeah.
What then?
I think there's a couple things. Number one, you want to assess their age and their compensation, right? Is the compensation in line with market? If not, you might need to align it up with market. Age, are they about looking to retire? If so, there's a risk, even if they're in their like 60s or maybe they're late 50s. But you gotta take a look at those issues. You have the kind of intangible personal thing, especially if you have a seller that's working with several of these individuals, and how do you, for lack of a better word, how do you jibe with them? And that's something that's very difficult to really understand until you sit down with them and you have a conversation with them and you kind of you kind of get comfortable with them in that way. Of course, another thing is there, if one of them has a relationship with the seller, they're a son, they're a daughter, they're a nephew, that's another indication that might not, first of all, that person might not be the best person for the role. But secondly, if they're there, then maybe there's not as much loyalty there. In a worst case scenario, maybe they felt like they should have inherited the business and you're coming in and buying it, there could be tension. So I think I would say those would be kind of the main things. I mean, in general, if people are being paid the same amount and doing the same job and are being paid at market, usually people like keeping their jobs, especially in this environment. But it's definitely a diligence issue.
Yeah, in the conversation itself, um, talk to them about the future, right? What do you want to do? What would what would you like to change? How do you want to grow? Right? Where do you see, right, that you can take this company? What, you know, future, right? Try to get a sense of, in the same way that you want to often talk to the seller early in the process about, what does your retirement life look like, right? To make sure the seller is right. Because if the seller gets that in their mind, it really helps them. It really helps you get to close. But you want to do something similar with your employees, right? You've been in this role, what are the things that we can do better, right? And if they're not telling you, right, that you're not getting a lot of, kind of early buy-in, that tells you something.
That reminds me of a interview in the Minds Capital podcast we did with an independent sponsor who um, it tries to use a similar question, James David, to gauge how successful the seller, who's going to continue on as CEO. So these are bigger businesses. Usually the seller continues on as CEO, rolls equity, how good a partner they'll be going forward. And it was essentially trying to tease out, in conversing with the seller, are they mostly interested in talking about the deal and deal terms or the future? And if their focus is all just on the deal and deal terms, and they're not that engaged when conversations about the future come up, I'm simplifying, but that's a tell that they're just not that, they don't care that much about the future. Bad partner for this sponsor. And there's similar kind of tactic here, James David, that you're trying to tease, see how they respond to questions about the future, and that could tell you a lot about how they're thinking about the future.
And I think, to that point, a lot of times people say more by what they don't say than what they do. And so, if you're an employee and a new employer comes around, they should probably be very interested in your future and what you're thinking and all that stuff too. If they seem kind of checked out, then, maybe they're kind of, thinking, they're looking at the exit too. Um, I'll just also say one more thing, which is you really kind of have to look at what the employees do and how competitive that job market is, because right now for white collar employees, it's really difficult for a lot of them, right? And so if those are the type of employees that you have, you're probably a little less concerned. Whereas if you're looking at like blue collar and trades employees, they have a much more robust job market, and so you probably have to be a lot more concerned to make sure that they're happy with their role and position. So just kind of keep some of those things in mind.
Yeah. We're at the hour, everybody. Let's do a couple quick ones. In an asset deal where you have to rehire the employees, at what time in the process do you start preparing the new employee contracts? James David, to your point about getting in front of stuff, would it be post LOI pre-close?
Yeah, it's often, often you're not doing that until the purchase agreement's almost final in the negotiation process. It's one of the later things that gets done. There can be certain states where it has to be pushed up, but often it's one of the last things that gets finalized.
Yeah.
Okay. Somebody asks what Rob's plan is. If you've never heard of Rob's, ROBS, you can Google it. The short version is it's a way of tapping the resources in your 401k plan, the money in your 401k plan to as equity for your business acquisition. It's quite involved. In fact, there's vendors who specialize in helping you do this. Lots to consider there. It's a webinar topic unto itself. But that's what it's for. For those people who have maybe are less liquid, but they have a nice sized 401k that they'd like to put that toward their business acquisition. You can look that up. But then a more specific question on Rob's. Bill, you mentioned the additional concerns about Rob. Somebody says, can you elaborate on whatever you meant there? Do you recall?
Oh, well, just to say that if you are buying there's a couple things. So first of all, there are requirements when you buy a plan through Rob's that you have to have like the 401k plan has to be offered the same to the employees as to you. And I mean, I'm really not a Rob specialist, but just know that when you're setting up your 401k, and you've used Rob's, there are certain requirements that come into place that when you're doing your setup, you kind of have to set things up a certain way. You also have to usually terminate the prior plan and create a new plan as part of the process. Otherwise, it just doesn't work, and you're not able to do it. So I'm not expert in those particular technicalities, but just know that there will be more involved. You'll talk to that service provider and you'll talk to your plan administrator and work up a solution that works. But it's it takes a bit.
Yeah. It's pretty involved.
Yeah, it's involved.
Great, guys. Well, let's close it there. Thank you for another great webinar. As always, do you want to tease those topics for next month and the following, Bill?
Yeah.
Go ahead.
So next month we will be doing a special on real estate, all real estate issues that come up from the legal perspective. And then the month after that, we're going to be diving into a lot of the technicals of working capital, especially not just how to calculate it, but how you deal with the mechanics legally in agreements. So
Always a very important topic. And real estate, we haven't had a webinar on that, so that'll be fantastic. Great, everybody. Thank you for your attention. We've been recording. You'll receive the recording and the slides by email. Watch for the announcement of next month's webinar with James, David, and Bill to come to that. And thank you guys for a great webinar as always. Any last thoughts? Okay, great. Thanks all. This ends the webinar. Bye-bye.